There's often a lot of confusion among the general public about the difference between burglary and robbery. In terms of the Texas Penal Code, it's important to remember you rob people, but you burglarize structures. You can't rob structures, and you certainly can't burglarize people. Under common law, burglary required a person to actually break into a house by smashing windows or doors. But the Texas Penal Code doesn't require this. In fact, some states may have a separate offense called breaking and entering, but Texas law makes no distinction between a violent or a nonviolent entry. It's all covered under burglary. There are three ways to commit burglary in Texas. First, a person commits burglary when they enter a habitation or building or any portion of such without effective consent which is not open to the public, with intent to commit a felony, theft, or an assault. So, for example, you break into a house with the intent to steal the television. Keep in mind, just the act of breaking in with the intent to commit the theft qualifies as burglary. Even if you get chased off by the family dog without the television, you've still committed burglary. Another important note is the statute only requires you enter without effective consent. So there's no difference whether you get in by use of a crowbar and smash the window, or just walk through an open and unlocked door if your intent is to commit theft. Second, a person commits burglary when they enter a habitation or building or any portion and, remaining concealed without consent, has intent to commit felony, theft, or assault. So, let's say you walk into a store just before it closes for the night and then hide with the intent to come out after everyone has left and steal merchandise. Unfortunately for you, a nighttime security guard catches you before you can commit the theft. In this case, the elements of the offense of burglary have still been met. Or finally, a person commits burglary when they enter a habitation or building or any portion and remaining concealed without consent, actually commit the felony, theft, or assault. So again, let's say you walk into a store just before it closes for the night and then hide. After all the employees have left, you steal merchandise and exit out the fire doors. In this case, again, even though you entered with consent, you have still committed burglary. Burglary of a habitation with intent to commit a felony other than theft, such as sexual assault, is a felony of the first degree. Burglary of any habitation, as well as burglary of a pharmacy, clinic, hospital, nursing facility, or medical warehouse with intent to steal prescription drugs, is a felony of the second degree. Finally, a burglary of a building other than a habitation is a state jail felony. Theft from the inside of an unoccupied vehicle is pretty common, particularly when victims leave their car doors unlocked and valuables in plain view. We'll discuss the Texas Penal Code offense of burglary of vehicles in this screencast. The Penal Code states a person commits burglary of vehicles when they break and enter or simply just enter into any vehicle without consent with the intent to commit a felony or theft. Similar to the Penal Code offense of burglary, there's no distinction in the method of entry as an element of this offense. It simply has to be without consent. So whether you pop a lock with a screwdriver, reach through an open window, or even reach into the bed of a pickup truck to steal something, if you've done it without consent, you've committed burglary of a vehicle. Burglary of a vehicle owned or operated by a wholesale prescription drug distributor is a felony of the third degree. Burglary of a rail car is a state jail felony, as is an offense if you have one previous conviction. In this case, the Penal Code also mandates a minimum 6-month jail term. All other offenses are A misdemeanors. There is one defense to prosecution to burglary of a vehicle. Railroads have always had a strong influence in Texas. An employee or representative of employees exercising a right under the Railway Labor Act, so in other words, a railroad union member, who is entering a rail car as authorized by the Railway Labor Act, may offer this as a defense to prosecution. The Texas Penal Code offense of criminal trespass is less serious than burglary, and unlike burglary, doesn't include any sort of intent to commit a felony, theft, or assault. In some sense, it's the act of being someplace that you're not allowed to be. It's important to note the 87th legislature made some significant changes to this statute and many other laws in passing what is known as constitutional carry. For our purposes,
we'll divide this statute into first, understanding the concept of notice, next, the set of laws that apply when the basis of the trespass is not related to possessing a firearm, and finally, when the basis of the trespass is indeed related to possessing a firearm. It's also important to note this screencast isn't all-inclusive regarding firearms laws in the state of Texas or constitutional carry. There are several other relevant statutes, including ones that carve out exceptions regarding places such as churches, schools, and amusement parks, so you should not consider this screencast as comprehensive or use it as legal advice on when or where you can carry a firearm in the state of Texas. This screencast is for academic purposes only and designed to explain the contents of Texas Penal Code Section 30.05 and 30.05 only. So first, one of the keys to the statute is the concept of notice. If you've ever been somewhere and somebody unexpectedly comes up to you and says, "Hey, you're trespassing," your first reaction might be, "I didn't know," or "there's no sign," or in other words, you didn't have knowledge of the trespass. The knowledge of the trespass is key to the criminal offense. Let's make a distinction here. In our previous example, you might very well be trespassing all right, but it's not criminal yet. What makes trespass criminal in Texas is if you have knowledge of the trespass, or it's reasonable that you should have had knowledge of the trespass and are doing it anyway. This knowledge comes through notice. A sign, symbol, fence, or somebody with legal authority telling you you're trespassing. Once you have received this notice, you are essentially culpable for the offense. The Penal Code recognizes many different kinds of notice, not just a sign. According to the Penal Code, notice means a sign or signs, oral or written communication by the owner or someone with authority, such as a peace officer or security guard, fencing or other enclosure obviously designed to keep out intruders or keep in livestock, purple paint placed on trees, posts, or property in vertical lines between at least 1 inch by 8 inches and placed at least 3 to 5 feet from the ground, and in locations that are visible and no more than 100 feet apart on forested land or 1,000 feet apart on land other than forested land. Or finally, the visible presence of a crop being grown or harvested. Let's move on from notice to criminal trespassing circumstances that don't involve possession of a firearm. The Penal Code states a person commits criminal trespass when they enter or remain on the property of another, including residential land, agricultural land, an RV park, a residential treatment center, or a building or a watercraft or other vehicle without effective consent when they received notice entry was forbidden, or they received notice to depart but failed to do so. So keep in mind, while a sign is the most obvious form of notice, the Penal Code considers any of these we just reviewed as notice, including someone in authority telling you that you're trespassing, a fence, purple paint, or planted crops. As a reminder, there are different sections of this law that apply when the basis of the trespass is the possession of a firearm. We'll discuss those in just a moment. In the meantime, for all of the circumstances we've just discussed, all of the following are A misdemeanors: criminal trespass in a habitation or shelter center, on a Superfund site, in a critical infrastructure facility, or on a college or university while having a previous conviction for trespassing on a college or university campus. A criminal trespass in which a person carries a deadly weapon during the commission of the offense. Note, don't confuse deadly weapon for firearm. All functional firearms are deadly weapons, but not all deadly weapons are firearms. Or the offense is committed on the property of or within a general residential operation operating as a residential treatment center are both A misdemeanors. Most other criminal trespass offenses are B misdemeanors. We'll talk about a few C misdemeanor exceptions in just a moment. For reference, a shelter center is defined by the Texas Human Resources Code and is a program operated by a public or private nonprofit organization that provides both residential and non-residential services to the victims of family violence. A critical infrastructure facility means locations such as a refinery, power plant, switching station, or water treatment facility, as long as they are completely enclosed by a fence or other physical barrier that is obviously designed to keep out intruders. The C misdemeanor criminal trespass offenses include trespass on agricultural land within 100 feet of the boundary or on residential land and within 100 feet of a freshwater boundary. This means if you go into a farmer's field or onto someone's property while tubing in a freshwater river, you are committing C misdemeanor criminal trespass as long as you are 100 feet from the boundary. If you get any farther than that, you would probably be committing a B misdemeanor. There are several defenses to prosecution for criminal trespass and one exception for all of the circumstances and types of notice we've been discussing. Once again, there is a different section of the statute for when the basis of prohibiting entry is possession of a firearm. First, it is a defense to prosecution the actor fell into one of these four categories: a firefighter or EMS acting in lawful discharge of duty under exigent circumstances, an employee of a utility company performing a duty within the scope of the agency, or for an employee of an agency who reasonably believed they had consent, a handgun license holder, and the basis of denial of entry was possession of a handgun. Basically, this language points out there are separate offenses for trespassing by handgun license holders, and for an employee or representative of employees exercising a right under the Railway Labor Act. The Penal Code states a defendant who has been charged with criminal trespass on a college or university campus while having a previous conviction, which you'll recall is an A misdemeanor, may raise the issue during the punishment phase of their trial that he or she was engaging in constitutional free speech or expressive conduct. The Penal Code states if this is proven by a preponderance of the evidence, the offense shall be punished as a B misdemeanor. So, in regards to all of the circumstances we've just discussed, it is a defense to prosecution to criminal trespass the act was part of a peaceful or lawful protest. If this is the case, this issue may be raised at the punishment phase by the defendant, and if proven by a preponderance of the evidence, enhanced penalties for shelter centers, Superfund sites, or critical infrastructure facilities will not apply. Finally, is an exception to prosecution. In other words, this law does not apply to persons when the basis of denial of entry was possession of a handgun and the person was a peace officer or federal law enforcement officer. As we previously alluded to, the 87th legislature made some significant changes to the law through the passage of what is known as constitutional carry. Again, all the previous circumstances and types of notice we just finished discussing are distinct from the type of notice which is required when the basis of the criminal trespass is the possession of a firearm, and the person carrying the firearm does not have a license to carry. Before proceeding, we need to make it clear that private property owners may determine whether or not they want persons on their private property with firearms. A person who is in control of private property may prohibit a citizen from entering the private property with a firearm. According to the Penal Code, a person may provide notice that firearms are prohibited on private property by posting a sign at each entrance to the private property that includes language that is identical to or substantially similar to the following: pursuant to Section 30.05 Penal Code, criminal trespass, a person may not enter this property with a firearm. The sign must be in both English and Spanish, in contrasting colors with block letters at least 1 inch in height, and displayed in a conspicuous manner clearly visible to the public. An offense under this section is a C misdemeanor, punishable by a fine not to exceed $200 if the person enters the private property, land, or building with a firearm or other weapon, and the sole basis on which entry on the private property, land, or in the building was forbidden is possession of a firearm or other weapon, except that it is an A misdemeanor if it is shown on the trial of the offense that, after entering the private property, land, or building with the firearm or other weapon, the actor personally received from the owner of the property or another person with apparent authority to act for the owner notice that entry with a firearm or other weapon was forbidden, as given through oral or written communication, or if the actor is unable to reasonably understand the notice described, other personal notice that is reasonable under the circumstances, and subsequently failed to depart. It is a defense to prosecution under this section that the basis on which entry on the private property or land or in the building was forbidden is that entry with a handgun was forbidden and the person was carrying a license to carry a handgun issued under Subchapter H, Chapter 411 Government Code. In other words, a Texas LTC. And the handgun was in a concealed manner or in a shoulder or belt holster. What this essentially means is that handgun license holders are not subject to the portions of this criminal trespass statute that pertain solely to handguns under Penal Code 30.05. LTC holders are subject to similar requirements, but they are found under Penal Code sections 30.06 and 30.07. So if a private property owner wants to prohibit all guns, both those carried under constitutional carry and carried under a LTC, the private property owner needs to post additional signs found in Penal Code 30.06 and 30.07. It is a defense to prosecution that the basis for forbidden entry was a landlord-tenant contract prohibiting possessing a firearm or ammunition on or at certain condominiums, apartments, rental homes, or manufactured home lots by the owner or renter of the condominium, apartment, or home, or their guests, as long as the owner, renter, or their guests was going directly to or from their vehicle and their residence with the firearm or ammunition, or was storing the firearm or ammunition in their vehicle or residence. Similarly, it is also a defense to prosecution the conduct occurred on hotel property, and the basis on which entry was forbidden was a firearm or firearm ammunition, and the actor was a guest of a hotel, motel, inn, or similar business, and the actor carried or stored a firearm or ammunition in the actor's hotel room, carried a firearm or ammunition directly en route to or from the hotel or the actor's hotel room, carried a firearm or ammunition directly en route to or from the actor's vehicle located on the hotel property, including a vehicle in a parking area provided for hotel guests, or carried or stored a firearm or firearm ammunition in the actor's vehicle located on the hotel property, including a vehicle in a parking area provided for hotel guests. The 87th Legislature significantly revised the Texas laws pertaining to the carrying of a handgun by a license holder. In this screencast, we'll discuss the Penal Code offenses of trespass by license holder with a concealed handgun and trespass by license holder with an openly carried handgun. The 87th Legislature made some significant changes to these statutes and many other laws in passing what is known as constitutional carry. Please note, this screencast isn't all-inclusive regarding firearms laws in the state of Texas. There are several other relevant statutes, including ones that carve out exceptions regarding places such as churches, schools, and other locations, so you should not consider this screencast as comprehensive or use it as legal advice on when or where you can carry a firearm in the state of Texas. This screencast is for academic purposes only and designed to explain the contents of Texas Penal Code sections 30.06 and 30.07 and these sections only. First, it's important to note these offenses pertain only to those carrying a license to carry a handgun under the authority of Subchapter H, Chapter 411 Government Code. These offenses do not apply to someone carrying a handgun under other circumstances. Next, these offenses pertain only to private property, or as indicated in the statute, property of another. Private property owners may determine whether or not they want a handgun license holder carrying concealed or openly on their premises. A person who is in control of private property that is a public place, such as a business, may permit concealed carry by a handgun license holder but prohibit open carry by a handgun license holder on their premises, or prohibit concealed carry by a handgun license holder but permit open carry by a handgun license holder on their premises, or prohibit both concealed and open carry by a handgun license holder on their premises. The first of the two handgun license holder offenses under Chapter 30 of the Penal Code is Section 30.06, sometimes referred to as 30-06. It addresses penalties for a handgun license holder who is carrying concealed on private property and without consent of the person in control of the property. The Penal Code states a handgun license holder who carries a handgun onto the property of another without effective consent, after having received notice that entry on the property by a handgun license holder with a concealed handgun was forbidden, or who remained on the property after being advised it was forbidden and failed to depart, commits an offense. Notice is familiar to us in the form of the 30-06 sign. The Penal Code provides specific written requirements for the sign, including that it have a specific statement on it, be in both English and Spanish, appear in contrasting colors with block letters at least 1 inch in height, and be displayed in a conspicuous manner clearly visible to the public. A handgun license holder with a concealed handgun who disregards proper notice, for instance, a properly posted and displayed 30-06 sign, commits a C misdemeanor with a maximum fine of $200. Should the handgun license holder then be personally given the notice by oral communication by the owner of the property or someone with apparent authority to act for the owner that they may not be on the property with their concealed handgun and they refuse to leave, the offense becomes an A misdemeanor. The 30.07 statute is very similar to the 30-06, with the exception of that it applies to a handgun license holder who is openly carrying his or her firearm. It states that a handgun license holder commits an offense if he or she openly carries a handgun on property of another without effective consent after having received notice that open carry of the handgun was forbidden. Just like 30-06, 30.07 has a sign requirement with specific language. The sign must be in both English and Spanish, be in contrasting colors with block letters at least 1 inch in height, and be displayed in a conspicuous manner clearly visible to the public. Also like 30.06, a handgun license holder with an openly carried handgun who disregards proper notice, for instance, a properly posted and displayed sign, commits a C misdemeanor with a maximum fine of $200. Should the handgun license holder then be personally given notice by oral communication by the owner of the property or someone with apparent authority to act for the owner that they may not be on the property with their openly carried handgun and they refuse to leave, the offense becomes an A misdemeanor. Since there are two separate laws, one addressing a handgun license holder carrying concealed and the other addressing a handgun license holder carrying openly, then there are two separate signs. Should a person in control of private property, such as a business owner, want to prohibit both concealed carry and open carry, they must post both signs. If they only want to prohibit one, they need only post the appropriate sign. Signs are probably the most frequently encountered forms of notice, but the statutes allow for other forms as well, such as passing out cards with the same required language printed on them. It is an exception to the application, which means no charges may be filed if the property on which the license holder carries a handgun is owned or leased by a governmental entity and is not a premise or other place on which the license holder is prohibited from carrying the handgun under Penal Code Section 46.03 or 46.035. There are several defenses to prosecution. First, it is defense to prosecution to both 30.06 and 30.07 that the license holder is an owner, guest of an owner, tenant or guest of a tenant of an apartment, condominium, or manufactured home lot, and the license holder was storing their firearm in their residence or vehicle or traveling between the two. Next, it is a defense to prosecution to both Penal Code 30.06 and 30.07. The handgun license holder is a first responder, as defined by the Penal Code, which means a public safety employee whose duties include responding rapidly to an emergency and includes fire and EMS personnel, but does not include volunteer EMS personnel. The handgun license holder who is a first responder holds an unexpired certificate of completion under the government code, and he or she was engaged in the actual discharge of the first responder's duties while carrying the handgun and while employed or supervised by a municipality or a county. It is also a defense to prosecution of both 30.06 and 30.07. The conduct occurred on hotel, motel, inn, or a similar business at which the handgun license holder is a guest, and the handgun license holder was storing their firearm in their room or vehicle or traveling directly between the two. Finally, it is not a defense to prosecution of either 30.06 or 30.07. The handgun license holder who was trespassing was carrying their firearm in a holster.